Good morning and welcome to today's administrative meeting of the Public Service Commission. We have a pretty busy docket this morning and we're getting started fortunately right on time. Before we jump into the meat of today's meeting, I'd like to start with some lighter fare. A couple personnel announcements. First, I'd like to announce that we have two summer interns, actually fall interns, starting with us just this week. We have Meda Vengopal and Harrison Sher. Meda is in the back row there. Harrison, unfortunately, is not with us today. Meda comes to us from the University of Maryland Law School, just down the block, where she focuses on a number of issues, including immigration issues, where she's the vice president of the Immigration Law and Policy Association. With an undergraduate degree from Rutgers in New Brunswick, she brings a lot of talent, and we're lucky to have her here on the 16th floor, so thank you, Meda. Harrison comes from our other law school here in town, the University of Baltimore, where he focuses on environmental law. He's had a number of very distinguished environmental positions over the past few years, and recently came back from Africa, where he was at the University of Malawi studying some environmental and comparative justice, looking at the laws of Malawi versus the United States. So welcome to both. We expect that they'll have a great stay and learn a lot while they're here with the Commission. I'd also like to announce the promotion of Joey Chen. Where is Joey? In the back corner. Everybody's in the back row today. Joey's been with the Commission since 2016 as our Associate General Counsel, working on a wide variety of regulatory issues. Prior to that, he came from the law firm of Saul Ewing here in town. We're lucky to have Joey join the 16th floor, where he's going to be serving all of the commissioners in the position of Senior Advisor to the Chairman. He also has an undergraduate degree from the University of Rochester in pharmacology, so he has a wide array of experience in his background. So I'd like to welcome Joey. Thank you for agreeing to join us and working with the commissioners. With that, do any other commissioners have any announcements? Seeing none, Madam Secretary, why don't we begin today's consent agenda? Yes, the minutes. Thank you, Commissioner Richard. We have minutes prepared for us by Sue Thomas. I'd like to recognize Sue, who's always at the front table here, typing away, producing minutes, and doing a number of other tasks, some of which I probably don't know about, but she's here with us every administrative meeting preparing the minutes. Looking back at last week's minutes, do I have a motion?
Yes, Mr. Chairman. I move we adopt the August 29th administrative meeting minutes.
Thank you. Is there a second?
Second.
All in favor?
Aye.
Great. Thank you. The minutes are approved. Now, Madam Secretary.
Thank you, Mr. Chairman. On the consent agenda, there are two items. The first item is Sandpiper Energy, filed on July 30, 2018. Its list of designated weather stations in compliance with COMAR Section 2031-0305. And the second item is Washington Gas Light Company, filed on July 30, 2018. Its list of designated weather stations in compliance with COMAR Section 2031-0305.
Thank you. Is there a motion?
Yes, Mr. Chairman, I move that we approve the weather station designations for the purpose of determining when there is an extreme weather period that requires restrictions on natural gas service terminations under COMAR 20.31.03.03 and 20.31.03.04.
Thank you. Is there a second? Second. All in favor?
Aye.
The motions are approved.
Turning to the administrative agenda, the third item is PowerMark Resources, filed on August 17, 2017, an application for a license to supply natural gas or natural gas supply services in Maryland.
Item 3, good morning, Chairman, Commissioners, Michael Dean on behalf of staff. Item 3 is an application filed by PowerMark Resources, LLC, for licensing as a natural gas supplier in Maryland. Under Public Utilities Section 7-603, a person must obtain a license in order to operate as a gas supplier, improve technical and managerial competence and willingness to comply with regulatory requirements. Staff reviewed the application and determined that it was missing a bond, a Maryland resident agent, and owner resumes. Staff notified the company several times of these issues but the company was non-responsive in providing the required items. Staff therefore recommends that the Commission deny the company a license to operate as a gas supplier in Maryland without prejudice.
Thank you, Mr. Dean. Is the representative from PowerMark with us today? Seeing none.
Mr. Chairman, can I ask a question of staff on this? Mr. Dean, why does the staff recommend without prejudice in this case? And the reason I'm asking that question is, if we're silent, that doesn't connote prejudice necessarily, but the statement of without prejudice almost indicates sympathy in my mind, to use a layman's term, to the application, should it be reapplied for. It just seems to me that a non-responsive, without an explanation as to why they're not responsive. I mean, if we had an explanation and we understood it, but we knew we still had to remedy a few things, we might say without prejudice. But they haven't even given us a reason why they're non-responsive. Why without prejudice?
It was simply to ensure that in the future, someone looking at the record would understand that there was no indication that the company could not refile for their application, and to also notify parties such as other state agencies that there's nothing considered detrimental in our refusal to license the company, because other agencies may look at a refusal to grant an application and give some serious weight to it.
Okay, so stating without prejudice doesn't preclude us from weighing this failed application should they reapply, correct?
That's correct.
Okay, fair enough. Thank you.
Any other questions?
Yes, Mr. Chairman. Good morning, Mr. Dean. I just wanted to make sure that PowerMark Resources was not currently active in Maryland. According to their website online, they have Maryland sales offices. Do we know that they're active at all here?
They're licensed as an electricity supplier.
Okay. All right, then that means they are active. Thank you.
With no other questions, is there a motion?
Mr. Chairman, I move we would deny the application without prejudice.
All in favor?
A second.
The motion is approved. The application is denied.
Thank you.
Items 4 and 5 can be called together. Item 4 is Taurus Advisory Group, LLC, filed on July 2, 2018, an application for a license to supply natural gas or natural gas supply services in Maryland. And item 5 is Taurus Advisory Group, LLC, filed on July 2, 2018, an application for a license to supply electricity or electric generation services in Maryland.
Good morning, Chairman and Commissioners. Peter Wilson for staff. Pursuant to Public Utilities Articles 7507 and 7603, Taurus Advisory Group has filed applications for licenses to operate in Maryland as a broker and aggregator of electricity and natural gas in all Maryland service territories, serving all customer classes. Staff has reviewed the application and has determined that the company meets all requirements to grant authorization as requested. The company has no complaint history in Ohio and New Jersey, where it currently does business, and has provided the bond required by Comar 20.51 and 20.54. Staff has reviewed the company's website and marketing and training materials and finds them satisfactory. For these reasons, staff recommends the Commission grant the company licenses to operate as an electricity and natural gas broker and aggregator for all customer classes in all Maryland service territories as requested, and direct the company to notify the Commission within 30 days of any changes to the information in its application.
Thank you, Mr. Wilson. Do the Commissioners have questions? Seeing none, is there a motion?
Mr. Chairman, I move the Commission grant the company licenses to operate as a natural gas supplier and as an electricity supplier in Maryland, limited to broker and aggregator services for the customer classes and service territories applied for and recommended by staff, and further to direct the company to file notice with the Commission within 30 days of any changes to the information in the applications.
Second.
All in favor?
Aye.
The motions are approved.
Item number 6 is Potomac Electric Power Company, filed on July 5, 2018, revised tariff pages. The company proposes to revise its street lighting rate schedules SSL OH and SSL UG.
Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. This is revised street lighting rate schedules SSL-OH and SSL-UG filed by the Potomac Electric Power Company on July 5, 2018, and requesting that the proposed rates become effective with usage on and after August 5, 2018. The revised rates update contributions in aid of construction costs and also include a new gross-up factor that removes the effects of the Tax Cuts and Jobs Act of 2017. Potomac Electric Power Company's street lighting tariffs are dictated by the terms of the stipulation and settlement reached in Phase 2 of case number 9217. Similar to Maryland residential service line installation fees, the one-time contribution in aid of construction for the company to install, remove, or convert each street light must be updated annually and is equal to the average estimated cost per street light during the most recent 3-year period available. The Congress of the United States passed and President Trump signed the Tax Cuts and Jobs Act of 2017 on December 22, 2017, to be effective January 1, 2018. One of the key provisions of the Tax Cut and Jobs Act is a reduction in the federal corporate income tax rate from 35% to 21%. In response to the Act, the Commission has generally required the utilities to adjust rates and make refunds of taxes overcollected since January 1st. With respect to the street lighting rate classes, staff's comments provide a breakdown of the estimated overcollection by installation, and PEPCO has provided information that the total overcollection is in the street lighting rate classes is $2,152.28. Staff has reviewed the filing and PEPCO's responses to staff's data request and agrees that the rates are calculated correctly and with the amount of the overcollection. Accordingly, staff recommends the Commission accept the proposed tariff revisions for filing to be effective with usage on and after September 5, 2018. Staff further recommends that the Commission direct PEPCO to refund the overcollected monies due to the Tax Cut and Jobs Act of 2017 and the tax error in existing tariff pages as a one-time bill credit. Finally, the Commission should direct PEPCO to work with staff to develop metrics that both support and evaluate the variation between actual costs and estimated cost.
Thank you, Mr. Spivak. Just a question. It looks like we have 800 and some odd refunds going to 37 customers. How do we get that number? Is there multiple refunds per customer, obviously?
Yes. I mean, the customers in question here are municipalities, so that they are the customers to whom we believe the refunds would be appropriately given. And yes, because they are in different, I think it's because they're in different locations, but I'll let Mr. Baker speak to that.
Anything to add, Mr. Baker?
Commissioners, Ben Baker on behalf of staff. No, the 37 different customers had 800 and something transactions, and so that's for multiple customers.
Easy enough. Thank you. Mr. Seegers, sorry, I didn't recognize you.
Not a problem at all. Good morning, Mr. Chairman and Commissioners. Matt Seegers appearing on behalf of PEPCO. The company has reviewed staff's buck sheet, and we have no issues with staff's recommendation that the Commission accept the proposed tariff revisions, nor does the company have any issue with staff's request that PEPCO work with staff to develop the metrics to support and evaluate the variation between actual and estimated costs. Regarding staff's recommendation that PEPCO be directed to refund the overcollected money due to the TCJA and the tax error as a one-time bill credit, this is not PEPCO's preferred method of giving this money back. Instead, what PEPCO is proposing to do is to donate the overcollection as a charitable contribution for two main reasons. First of which is that, as staff notes on page 4 of its buck sheet, the total amount that would be refunded would be $3,427.28, but the cost of refunding this amount would be $8,755.48. And I would like to note a correction on page 4 of staff's buck sheet. It would be $35 customers that would be refunded, not 37. But the reason that this cost would be incurred is because each one of these items would have to be refunded through Pepco's special billing department. What Pepco's special billing department does is they process any kind of a payment that is outside of a normal service payment, like a contribution in aid of construction or a service connection fee. As staff notes in its book sheet, there are 868 accounting journal entries associated with these refunds, and each one of those would have to be reversed by our special billing department. So unfortunately, there's no way to avoid that labor cost associated with these refunds. And because the cost of refunding the overcollection is significantly greater than the amount that would be refunded, it just doesn't seem to make sense for us to refund these to these individual customers. And this would also be consistent with the Commission's recent handling of our refund of the service connection fees. I note that staff does say that the labor cost associated with the refund is not incremental and that it is already bundled in the rates. And while this may technically be true, this was also the case with our service connection fee refund. The labor costs associated with those were not incremental as well. And staff doesn't make any kind of a distinction between the two, and I don't see why the two should be distinguished, given the Commission's recent handling of our service connection fee refund.
Although, Mr. Seegers, in that case, the customers were not identifiable. Here we have 35 identifiable customers. Is that true?
In the service connection fee, the customers were able to be identified. Essentially, it was the developers who initially paid the service connection fee, but then they built it, as I believe Commissioner O'Donnell noted at the June 6th administrative meeting, the developers built the cost of that service connection fee into the home that they sold to the who became our eventual customer. So the customer, they indirectly paid that fee. So we were able to identify the customer there. It's just in that case, as in here, the cost of giving the refund just greatly outweighed the amount that would be refunded.
Thank you, Commissioners.
I'm sorry. Did you have another question, Mr. Chairman?
I did not.
I also wanted to point out that another difference between this, the contribution aid of construction refund and the service over collection refund, is that here there is a question as to whom should be getting the refund. And by that I mean this. As previously noted, there would be a total of 35 refunds that would be issued. Each one of the majority of each one of these refunds would be going to developers. Of the 35, there's only 9 active customers that we currently have who have made these payments. And essentially, but the problem is that the developers likely have already been made whole, in the sense that when a developer comes along and they say, I want to build a development, and a county or a city says, okay, we want you to put in 10 streetlights. The developer will come to us, they will pay the contribution, and then they will most oftentimes build that contribution into the cost of the development that they sell to a homeowner or a business. However, once the streetlight is built, the developer will turn that streetlight over to the county or the city, but the county or the city will not have indirectly paid that contribution, unlike the service connection fee. So, so really, there is a question as to if it is right that that a refund that was paid by a developer should go to a developer who likely has already been compensated, or to a city or county who did not indirectly pay that contribution. So I did want to raise that issue, and it's for these reasons why we have taken up a suggestion that was actually made by Commissioner Herman at the August 8th administrative meeting, that we give this as a charitable contribution. As staff's buck sheet notes, we have identified the Washington Area Fuel Fund, which is a partnership between the Salvation Army and Washington Gas that covers the Washington, D.C. area, including the Pepco service territory.
Thank you, Mr. Seegers.
Question. So, Mr. Seegers, isn't this effectively forcing these 35 customers to make a charitable contribution to the Fuel Fund of Maryland?
That could be one way of looking at it, yes, Commissioner.
And how do you spend other people's money like that?
We view this as trying to stay consistent with how the commission handled the service connection fee filing, where if the costs of the refund just very much outweigh the amount that will be refunded, it would just not be a good
Right,
use.
but there were assumptions made in that case that distinguish it in my mind, which is you're assuming that the developer passed that on to the customer. They probably did, but that's not verifiable. Maybe they did, maybe they didn't, and you couldn't refund to the customer because they didn't pay it. The developer did, and so you're really taking the developer's money then and giving it to the customer, which may be proper, but it was a little bit different in that situation than this. Here you have the customers clearly identified, and the money would go directly back to that customer who paid the overage, the over collection.
Actually, Commissioner, in only 9 of the cases was the contribution paid by the person that is our active customer. All of the others would be essentially a check going back to the developer.
Let me ask you this: who would pay this is effectively, on average, $250 and change per customer over collection. Who would pay the cost of returning that $250 on average per customer? Would it be the ratepayers in a rate case, or would it be the investors in the utility? Who would, at least theoretically, pick up that? Would it be cooked into labor and administrative costs or expenditures in a base rate case, or would it be the investors?
Well, as of right now, as staff notes in their buck sheet, the labor costs would not be incremental, so technically they are baked into our rates. So as of right now, it would be the utility that would pay any labor costs, or if we're mailing checks, any postage, any stock for the paper for the checks. That would be the utility, and then in our next rate case, we could have the opportunity to come in and get reimbursed for those.
So a lot of this, I understand the mathematics and why it doesn't make sense to spend more money good after bad, but there's a principle in play here as well, in that the company is over-collected from consumers. And they just propose to just keep that money and give it away, reaping the goodwill and benefits of giving such monies away. And it's small amounts, it may seem inconsequential, and I don't intend to nick one dime, but we're seeing more and more of these because of the TCJA, and I don't think it's necessarily a good idea to set precedent that we give other people's money away automatically.
Understood, Commissioner. And the company was just trying to stay consistent with the Commission's handling of the service connection fee. There, it was passed through the BSA. Unfortunately, that's not an option here because these are street lighting classes and they don't have a BSA associated with them. So we were left with 2 options, and we decided to try and go with the charitable contribution as a preliminary proposal.
Mr. Seegers, it sounds like you've already identified if there were a refund ordered. The work has been already done to identify exactly who would get it and how much they would get. Is that correct?
That is correct, yes, Your Honor.
Okay. Mr. Spivak, refresh my recollection. When we originally did the refund for the Tax Act for Pepco, I think it was in February, were we aware that the service connection fee and the street lights were not included in that refund?
I think we were, because and again, I think I will let Mr. Baker speak in more detail, but my recollection is that we were aware that there were classes that were not included at that time.
And that we held off because we knew they were going to come in for annual fixes or annual updates. Sorry.
Ben Baker on behalf of staff again. No, the TCJA was passed through to the lighting classes. These fees were not within the rate case. They weren't discussed within the rate case. So our knowledge was not of these fees needing to be refunded at the time. That only happened once these came in I guess June and now respectively.
Okay. Thank you.
Mr. Spivak, oh, I'm sorry, you had something.
I just want to say I stand corrected.
Can I ask you a question, Mr. Spivak? since we're citing previous orders in consistency with previous orders, wouldn't the company's recommendation kind of violate our previous order in the TCJA with regard to identified future tax savings as a result of the TCJA, and that be also expedited to be refunded to the consumer or the payer?
That is what the order said, Commissioner.
Thank you.
I think you answered the question I had to Commissioner O'Donnell, but just to be clear, this $8,000, the special billing department already exists. People show up to work every day. The paper has already been purchased for the checks paper stock. So, I mean, are there savings to ratepayers if we don't issue these checks to the customers, the 300 or the 35 customers? I'm just trying to understand what the overall impact of this decision we're about to make.
I don't believe there would be any immediate cost or savings to customers, Commissioner. The costs that we're presenting here are the same costs that we presented in the service connection fee refund, which essentially these are what it would cost us to process these refunds. And it is the same costs for each line item. It would be about $10 in labor, and then if we have to mail a check, it would be about $2.04 to include, as of before, the postage, any additional processing, the paper that the check's printed on. So, I hope, did that answer your question?
I guess, yeah, just trying to understand if the people not show up to work that day, if they don't have to do this task. I mean, it sounds to me like this billing department already exists. As it was put in the buck check, there are no incremental costs involved to returning the money to whom it's owed.
No, Commissioner, there would be no incremental cost.
All right, great, thank you.
Seeing no additional commissioners wishing to speak, I see the merits both ways on this issue. Efficiencies of just making the contribution, which I could support, as well as attempting to figure out who is owed the money and then go through the manual process of providing a paper check to them. So perhaps we, just so we're clear, perhaps take an informal vote of whether to go with Pepco's preferred option or staff's. So I would support the charitable contribution, respecting the concerns that were raised. Commissioner Richard.
If I understood some of the questions, I guess, that Commissioner O'Donnell was asking, I tend to want to actually give the money back to the people it's owed. And if the work has already been done, if I understood the answer to Commissioner Herman's question, the calculations have already been made, and there aren't really any savings to ratepayers since this billing department already exists and the paper's already been purchased. I guess I would be more inclined to go with the staff recommendation.
Commissioner O'Donnell.
I know that it's you could argue reasonably either way on this, and I understand the amounts are relatively insignificant when we consider the large rate cases we're talking about here, but as a matter of principle, I have to support the staff's recommendation here. We're going to continue to see more of these cases. I understand the sentiment, but I'm skeptical of the extra cost to return these monies, and I look at how we treat ratepayers when they underpay, and we're pretty inflexible with regard to that. When there's over collection, I think we should be as kind of, I hate to use this word, as cold-eyed as we are in those cases. And so for those reasons, I support the staff's recommendation, Mr. Chairman.
Thank you. Commissioner Linton.
Thank you, Mr. Chairman. I actually am coming right down in the middle on this one. I actually think that because the company is able to identify 9 customers who made the original payment, those customers should get the credit back because they are the ones that actually paid it. Traditionally, when we do require a refund for overpayments, it doesn't go to a new customer or a person with a new account. So for the 9 who have made the payment, they should receive the refund, and the remainder can be donated to the fuel fund.
Thank you. Commissioner Herman.
My inclination is that to support the staff recommendation, because in this instance, the customers have already been identified and all of that work has been done. At this point, I think we're just cutting checks, based on what I heard from Mr. Seegers. However, I think that I also like the concept that Commissioner Linton developed, where where you can identify the actual customer, so you could, where those customers can be identified, and I think that's a interesting compromise. Mr. Seegers, explain again, like, about the 9 customers who can be identified and the others, and what happens, who the others are.
Sure. For the 9 customers who made the contribution, we can certainly refund them, and that would be, that could be deemed appropriate because they're the ones who actually made the payment. In terms of all of the others, those payments were initially made by a developer who then would turn around, as Commissioner O'Donnell pointed out, I'm making a bit of an assumption here, but the developer oftentimes would turn around and build the cost of that contribution or that payment into the cost of the development that they would then sell to a homeowner or a business. The issue with the street light is that the developer would make the contribution payment to Pepco, and then they would build the street light, and then they would turn it over to the entity that would become our active customer, which ordinarily would be like the county or the city or a homeowners association. But the developer would not charge the county or the city for the street light. They would just turn it over to them. So the person who was our active customer for the payments that were made by developers, they did not indirectly pay the contribution, unlike the service connection fee. So if the commission is so inclined, I do see how it could make sense about how there could be a refund to the 9 active customers who did make the contribution payment. And then for the refunds that would go to a developer who likely has already been reimbursed, that could be made through a charitable donation.
So you've identified the developers
Yes, we have.
then. So you can refund to those developers.
Yes, we could.
Okay.
If I might, I would actually request that Councilor Pepco clarify when he's talking about the 9 active customers, that whether it seems that those are developers. Are the other 24 active customers, or 26 active customers, are those the municipalities we believe?
That is, yes. When for all of the others, those would be either it would be a city, a town, could be a homeowners association, but anyone who would. But yes, that would be our active customer.
Thank you.
So just to be clear then, when the street lighting was first developed, the town or the community association, whomever that's the current customer, was not the entity at the time that was the customer from the company's perspective. They weren't the one handling all of the arrangements, making payments, everything else that normally would happen from the customer to the company.
In all of but 9 cases, that is correct, Commissioner.
Mr. Chairman, just weigh in on the recommendation I think I'm hearing. I cannot support that idea. I think it greatly overcomplicates what is a very simple matter. Return the money, in my opinion, or don't return the money. That's the choice before us. That's the choice in the buck sheet. We didn't have this other information leading up to it. And I can't support it, because I think we're going to hear in the future, well, you did this in that case when you refunded on the street lighting case for Pepco, and now you're going to have these complications coming down the line. I think we should either bite the bullet one way or the other, in my opinion.
Thank you, Commissioner.
Yeah, I would support Commissioner O'Donnell. We're making a lot of, we're speculating here exactly how the developers use the money, whether they did build it into the project cost or not. So I kind of feel like we should just make this as direct and simple as possible, and just go with the staff recommendation.
Thank you. Everybody's had an opportunity to speak. I would ask if there's a motion at this time.
Yes, Mr. Chairman. For item number 6, I move that we accept the tariff revisions for filing effective with usage on and after September 5, 2018, and direct the company to refund the overcollected money due to the Tax Cuts and Job Act of 2017 and the tax error in the existing tariff pages as a one-time bill credit, and direct the company to work with staff to develop metrics that both support and evaluate the variation between actual cost and estimated cost.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion carries. Staff's recommendations are approved.
Thank you, Commissioner.
Thank you.
The next item on the agenda is item 7, Clean Choice Energy Community LLC, filed on July 27, 2018, request for an extension of operation deadline.
Michael Dean again on behalf of staff. Item 7 is a request filed by Clean Choice Energy Community LLC of an extension of the operating deadline for completing its 2 community solar energy generating systems under COMAR 20.62.03.04C, pending the resolution of legal challenges. The Commission recently adopted regulations under COMAR 20.62 for the qualification of community solar energy generation systems as defined in Public Utilities 7-306.2 and COMAR 20.62.03.04C provides that a project that fails to begin operations within 1 year after submission of its completed application, the electric company is to remove it from its pilot program queue unless the subscriber organization pays a penalty to the electric company, and if the project fails to begin operations within 18 months, the electric company is to remove the project from the queue. But this deadline for operations date may be extended on a day-to-day basis upon a showing that a government permit or approval was subject to a legal challenge that is ongoing. Clean Choice Energy obtained authorization for community solar energy generation systems, 2 systems, the Sassafras and Trillium projects located within Baltimore Gas and Electric Company service areas in Baltimore County, and the electric company placed the projects on its project queue in August 29, 2017. As discussed in the filing, both projects were granted special exemptions under the county zoning ordinances and were then subjected to ongoing legal challenges of the grant of the special exemptions before the County Board of Appeals. At this time, it is not known when the zoning issue legal challenges will be resolved or concluded. Staff has reviewed the filing and determined that the Clear Choice projects meet the regulatory criteria for the granting of the day-for-day extension of the deadline for commencing operations under the regulation. Staff recommends that the Commission direct Baltimore Gas and Electric Company to extend the operation deadline separately for the Clean Choice Energy Community LLC Sassafras and Trillium projects located in Baltimore County on a day-for-day basis under COMAR 20.62.03.04D3B until the legal challenges pending for each project has ended. The Commission should direct the applicant to report to the Commission within 30 days of the date when each legal challenge is no longer pending.
Thank you. Is counsel for Baltimore Gas and Electric present? If you could approach the staff podium. Mr. Begelmans.
Good morning, Mr. Chairman, Commissioners. David Begelmans on behalf of Clean Choice Energy Community LLC. I think Mr. Dean was thorough and accurate with his summary of our request. This is very similar to a request that was filed by another developer, Cypress Creek Renewables. I believe the Commission heard that request about 3 weeks ago. Essentially, both projects have received special exceptions from Baltimore County, but those approvals have been appealed to the Baltimore County Board of Appeals, which is sort of the first step in the appeal process. Those requests are currently undergoing hearings. We expect those processes to be complete by the end of December. However, we expect further appeal, and similar to Cypress Creek, at this time we simply do not know when the appeal process will end. But as Mr. Dean indicated, the regulations are clear that it's simply a automatic day-to-day extension until the legal challenge has been completed. I'm more than happy to answer any questions from the commissioners. Thank you.
What is the state of your communications with Baltimore Gas and Electric?
My
Why are you here is my question.
So we're here for two reasons. At the time that we filed the request, Baltimore Gas and Electric hadn't responded to the developer. At the same time, we had seen that Cypress Creek had filed a request, and we wanted to be consistent with that. As the Commission knows, these projects are progressing quickly. The deadlines are fast approaching. We wanted to make sure that this request was before the Commission. And when we saw that the Commission considered the Cypress Creek request, which is virtually identical to this one, we thought it was appropriate to keep it in the administrative meeting queue and follow through with the hearing.
Is your official position that the Commission need not take action, however?
I think there's two views. I think Comar is clear that BGE essentially shall issue a day-to-day extension. But I think in order to remain consistent with the Cypress Creek ruling and to ensure that BGE is comfortable that this is a qualifying appeal, I think it would be prudent for the Commission to rule on the request, just in the matter of consistency.
Thank you. Does Counsel for Baltimore Gas and Electric have a response?
Morning, Mr. Chairman, Commissioners. Daniel Herson for Baltimore Gas and Electric. I'm in an unusual situation this morning. I literally just learned about this matter sitting next to Mr. Bugelman, so I wasn't aware of it. So I'm not sure if we've had correspondence since the filing was made. I sent an email back to our office, and I'm told that Ms. Curry is en route and will be able to address this perhaps. So
You're in a tough spot, Mr. Herson.
I am.
Okay.
Maybe I could beg the Commission's indulgence to table this for a few minutes until she comes and move on to the agenda.
I don't know if that's necessary, but let's see if the other commissioners have questions.
I have a question for staff. Mr. Dean, do you know how many more of these Baltimore County CSEGS projects are in the queue for extensions?
I personally don't have that information.
Fair enough. As an aside to this proceeding, could staff let me know just so I have that information?
Certainly, Commissioner.
Thank you.
Any additional questions? Is there a motion?
Yes, Mr. Chairman, I would move that we direct the company to extend the operation deadline separately for Clean Choice Energy Community LLC's Sassafras project and Trillium project located in Baltimore County on a day-for-day basis under Comar 20.62.03.04C3B until the legal challenge pending for each project is ended, and direct the applicant to report to the Commission within 30 days of the date when each legal challenge is no longer pending.
Is there a second? All in favor?
Aye.
The motion passes.
Thank you.
The next item on the agenda, item 8, is Comprehensive Housing Assistance, Inc., filed on July 24, 2018, a request to use funds for its fiscal year 19 program administration from the Energy Home Loan Improvement Fund, case number 9271.
Peter Wilson again for staff. As part of the customer investment funds ordered by the Commission resulting from the BGE Exelon merger in 2012, Comprehensive Housing, Inc. received funding for its revolving loan and grant program for energy efficiency improvements to low-income households in Baltimore City and Baltimore County. By this filing, Comprehensive Housing requests to reallocate $53,684 from the loan pool for administrative expenses to continue the program into fiscal year 2019. The Commission has approved similar requests in the past, including a transfer of $57,298 for administrative expenses last year. Staff has reviewed the filing and filed data requests concerning the operation of the program. Based on its analysis and the Commission's past practice, staff recommends that the Commission authorize Comprehensive Housing to reallocate $53,684 from its Home Energy Improvement Fund loan pool for fiscal year 2019 administrative costs.
Thank you, Mr. Wilson. Thank you, Mr. Wilson. Any questions?
I have a question. Does staff have any indication how long this request for using these revolving loan funds for administrative fees is going to continue in? Because I think the original agreement was that Kai would take over the administrative costs of keeping this program going forward.
Good morning, Chairman and Commissioners. Matt Bonikowski for staff. It looks like we have a representative from Kai here who would probably be best suited to answer that question.
Fair enough.
Good morning, Commissioners. Phil Simons. I'm Chief Financial Officer at Comprehensive Housing Assistance, Inc. When this program was initiated, which was before my time with our organization, I want to say generally the funding environment for nonprofits was considerably more robust. We are finding times have become more challenging, and we are asking each program that we operate to bear its fair share. So the direct answer to your question is we don't know how many more times this question will be asked, but we'd like to take this 1 year at a time if we may, and we'd be very appreciative if you would approve our request.
Fair enough, Mr. Chairman. I think that that's a very frank answer. I also think that we should discuss, or at least have me mention, that I don't consider this precedential or an agreement or a modification of the original agreement for Kai to take over the administrative costs, and that we should entertain this on an annual basis if it continues on the merits fresh.
Thank you, Commissioner O'Donnell. Sometimes we don't know what the future holds.
Can I just ask staff, once the funds cycle through the program, and are they still considered SIF funds, or once they're repaid, is it just an ongoing revolving fund? I'm just curious what the status of that fund is.
Any repeat loan funds would go back into the SIF loan pool for the company.
Okay. And I guess the agreement at this point is there was only a one-time administrative fee, and in other words, if it costs $53,000 to continue to operate this year in, year out, still that should not be funded through the SIF dollars, even if those dollars have been recycled back through the program.
So that's what this request is trying to make funding available for.
Okay.
This request is to transfer money from the loan pool in order to cover administrative costs. By means of a little bit of background, Kai's was originally granted a $2 million disbursement through the Customer Investment Fund. Of that, I believe $375,000 was to cover administrative costs for the original 3-year program cycle. There was no consideration at that time to administrative funding after the 3-year cycle, and in Kai's original proposal, I believe is noted on page 3 of staff comments, Kai did agree to take responsibility for continuation of program and the administration of the fund at the conclusion of the CIF program.
At the conclusion of the 3-year program.
That is my understanding.
Okay.
I would note that the Commission did extend the CIF program to run 4 years, but at the conclusion of that 4-year program.
Okay, great. Thank you.
Thank you. Is there a motion?
Yes, Mr. Chairman, I move we grant Comprehensive Housing Assistance, Inc. authority to reallocate $53,684 from the Home Energy Improvement Loan Fund loan pool to cover fiscal year 19 administrative costs.
Is there a second?
Second.
All in favor?
Aye.
The motion passes. Thank you, Mr. Simons.
Thank you very much.
The next item, item 9, is Office of Staff Counsel filed on August 13, 2018, Budget Bill Proposal Empower Maryland Plans, case numbers 9153, 9154, 9155, 9156, 9157, and 9362.
Good morning. Michael Dean again for staff. Item 9 is the auto pay budget bill proposal filed by the staff on behalf of the Empower Maryland Behavioral Work Group. In order number 88783 of July 27, 2018, the Commission approved a proposal regarding a pilot addressing price signals to customers on utility budget billing, who therefore may not respond as favorably to home energy reports and other energy-saving opportunities as do non-budget billing customers. The order requested the work group provide additional information and file a auto-pay budget bill pilot implementation plan within 15 calendar days. In the staff filing on behalf of the work group, a non-consensus plan was provided. Staff in its filing also noted some concerns about the proposal and requested that the work group be given an additional 30 to 45 days and to issue a report prior to the fall Empower Maryland hearings. The Commission then issued a notice requesting comments from stakeholder and parties, and additional comments were filed by staff, the Office of People's Counsel, and yesterday by the Maryland Energy Administration mail log number 221883. Staff is here to answer any further questions that the Commission may have in regards to the proposal.
Thank you. Does Counsel for Office of People's Counsel have anything to add?
Mr. Chairman, Commissioners, good morning. Mikhail Raker for the Office of People's Counsel. I think we've stated most of our concerns in the comments that we filed. We agree with staff's recommendation to allow an additional 30 to 45 days to continue to discuss the proposal. Just as a brief update, we attached some DRs with our filing. The utilities did provide responses to most of those as of this past Friday, so we're reviewing those. In our comments, we asked for historical analysis for this particular pilot. In SMECO's responses to our DRs, they note that they would need about 4 to 6 weeks to compile that. We would recommend that with the extension, the Commission also direct the companies to begin to compiling those so that that analysis can be used as we discuss the pilot design. And so that would be all that I have to add that's in addition to our comments, but I'm happy to answer any questions.
Thank you, Mr. Raker. Do the ladies behind you wish to make an appearance?
Good morning, Mr. Chairman and Commissioners. Michelle Honig, Assistant Attorney General, appearing on behalf of the Maryland Energy Administration. With me today is Cindy Osordo. Ms. Osordo is a new program manager. She will be handling Empower Matters. Ms. Osordo.
Good morning, Commissioners. I'm here to answer any questions regarding MEA comments that were submitted. We generally agree with staff comments and OPC comments that there is concern regarding statistical significance for the pilot.
Thank you, Ms. Osordo.
Has MEA been an active participant in the work group proceedings?
I am the new program manager for Empower, and we have been active in listening, but not in the past year. But we are all caught up regarding this pilot.
So if an additional 30 to 45 days were to be granted by the Commission, MEA would be actively engaged in those discussions. Thank you. I appreciate that.
Thank you.
Looks like we have a line developing. The utilities, perhaps Mr. Michael first and then Mr. McDougall, and we'll go back and forth.
Good morning, Mr. Chairman, Commissioners. Douglas E. Michael appearing on behalf of PHI, the Pepco Company, and Delmarva Power and Light. If the Commission wishes to send it back to the work group for another 30 to 45 days, we're always happy to talk in the work group setting. But I just want to point out a couple factors with respect to the development of this program and some issues. First of all, it was our belief that this was a consensus program when we filed the initial work group report. We thought it was clear in the work group report and also clear in the Commission's order that it would either be a budget billing pilot or an automated pay pilot. And we're proposing, and we were ready to do a budget billing pilot. I think all along we've been clear that the numbers that we get may not be statistically significant, and indeed we've provided some data request responses indicating that there are some statistical issues, but that does not mean that the budget billing pilot, as we've set it out, is not something that is worth doing. It is something worth doing, and I think we've got evidence that changing, the budget billing pilot or the HERS report for the information in the HERS report, the home energy report for budget billing customers can have some impact, and we're ready to do that. I think you saw in the report that was filed in August that we set out the 7 conditions that the Commission determined that we meet for a pilot, and I think the staff bug sheet indicate that we've met that pilot. So we're willing to continue to talk, but I can't guarantee that a whole lot more is going to be accomplished.
Can I just ask the question? When did the two groups get separated, the budget bill and the auto pay? Because I guess going into this, I thought we were trying to reach all of these individuals who weren't getting the price signals because they pay a flat amount, or they didn't have, they weren't paying attention to their bills.
The two groups were separated from the beginning. In the initial pilot program, there is a footnote 11 that says specifically, this will either be a budget billing or an auto pay pilot for a single utility, but not both. So we were very clear on that when we were designing the pilot. And then when I look at the Commission's order approving this, you dropped a footnote. It is your footnote 43 that, again, let me just find the order here. It's order 88783. The Commission's footnote 43 notes, quote, this will either be a budget bill or auto pay pilot for a single utility, not both. And part of the reason we wanted to do it, and you can't, I guess, and I'm not the statistics person, but this is what my statistics people tell me, that there are different attributes for a budget billing customer and an auto pay customer, and you ought not combine those customers because those groups are different groups, and so just combining them, you get a better number, but it doesn't statistically help your statistical analysis.
Okay, so even though it builds the pool, it doesn't, and hopefully by building the pool, we'd get to that statistically significant, we would not have...
But you have to have people in the pool, or groups in the pool that are the same type of customers. Okay. And there's a significant difference between a budget billing customer and an auto pay customer. I think that's borne out in some of the research that OPC even cited in its comments. And I would let Mr. Hutters, if you're interested in the statistical part of it, to talk more about that.
Okay, thank you. This was I like the hypothesis that perhaps by not getting the price signals, and I know at one point we talked about both these groups, the auto pay and the budget billing, and so I guess I should read carefully our own footnotes. I thought we had combined the two together, but I still think it's an interesting program, and I would hope that we can get this going sooner than later. But anyway,
Mr. McDougall.
Mr. Chairman, Commissioners, Mark McDougall on behalf of SMECO. I echo PEPCO's comments in large part. The one thing that Mr. McKeel did not mention that I would like to is that in the April 10th proposal, staff mentioned that the second pilot, the one that we're talking about today, would measure different marketing messages with these budget billing and auto pay customers who might miss out of the traditional opportunities to notice and pay attention to their energy usage. SMECO was viewing this pilot as an opportunity to measure whether these customers of ours opened the letter, clicked on the email to give them the information they needed to make the informed choices to whether or not to participate in an Empower Maryland program. We thought this was important, and we, SMECO, believe that we are able to come up with good data on that test, on that pilot. the part of the pilot that we believed would be difficult to measure, the statistical significance, was on the savings that a specific group of customers might be able to achieve. And if we were to ask to try to measure that, we would need to expand the set of customers to have greater numbers, as well as revisit whether we could do it under the existing budget, which I believe we cannot. We could do the pilot as proposed with the goal of determining whether or not these auto pay and budget billing customers receive the messages and get the information necessary to make their decision. But once having made that decision, the statistical significance comes into play as to actual savings.
Thank you, Mr. McDougall. Do we have other utilities wishing to speak? Other parties wishing to speak? Mr. Dean, perhaps you could help me understand. At what point did these two different billing groups, customer groups, get merged together? It seems like the order stated that auto pay and budget billing were to be separate, and now it appears that the work group wants to deliberate on both of them combined. Mr. Hurley.
Good morning, Mr. Chairman, Commissioners. Dan Hurley on behalf of staff. In the April 10th work group report, it was noted as an auto pay or budget billing program. In the Commission's order, as Mr. McHale pointed out, the footnote 43, which I think was part of the review of might have been part of the review of the proposal, indicated the proposal was stating that it was going to be an auto bill or a budget bill. But then with the Commission order, it seemed like it could have been both. So it was a little bit unclear. So I think there's just some uncertainty with the energy savings statistical significance. Just to step back, I wanted to raise the issue in this latest report in the compliance filing because I don't think it was emphasized enough in our first report, and I don't believe it was very emphasized during the discussions at the last Empower hearing. So I wanted to make sure the Commission was clear about that. The energy savings were not going to be statistically significant. I just wanted to make sure the Commission was aware of that for their information.
I'm sorry, the energy savings with respect to which group?
To either group, either the budget billing or the auto pay. Now, with the proposal from the utilities, it's focused on the budget billing customers.
I am concerned that we're mixing apples and oranges to some extent with respect to budget billing customers and auto pay customers here. So I do recognize the concerns expressed by the utilities. What would the utilities ask for in this case? A number of parties are asking for an additional period of time in which to work on the details, but it sounds like we have quite a gulf between the utilities and everybody else.
Pepco and Delmarva would like approval of the pilot programs to go forward as set forth in the initial work group report. And we believe approved by the Commission in its order. When I look at order paragraph 8 on page 23, it says the auto pay and budget billing pilot proposed by the behavior work group is hereby approved, and that's what we're asking for. And the additional information that the Commission asked, which I completely agree with, was to ensure that the program, the pilot program that we set forth, met the 7 requirements that this Commission has for a pilot, and that's what we filed with the work group in August.
So you would recommend denying the extension of time to deliberate and just go with what the Commission previously stated?
We would, but I mean, if the Commission thinks, a work group, we're always willing to talk and try to bridge our gulf. But I think we're kind of at a point where we don't believe that we can ever get it statistically significant because you need too big a sample size. The other issue is the Commission's report and order said that we had to do this program within the confines of our current contract. And as proposed, as Mr. McDougall pointed out, we can do that. But with all of these new items that we heard for the first time in the second work group, that's going to increase the costs, and I can't tell you what the costs are because I don't know what the outcome of the work group would be, but it would be an increase in our costs in our contract with Oracle.
So the cost would increase, and are you saying that the value of the data that's returned would decline?
Would remain the same. It would not be statistically significant for energy savings. I think that's my understanding from my experts.
So either way, we end up with unhelpful data.
Well, I don't agree with that. I think the program is worth doing because you're providing different information on the home energy report to folks who are getting budget bill, and you can see whether or not there's energy movement. The question is it statistic? Can you do a rigorous statistical analysis around it? I think it's clear, even from the information that we've seen in studies, that there is some help in doing this. And there's a study, I think it's from California, that indicated that, and they, for whatever reason, were able to get it statistically significant. What we're saying is we can't get it statistically significant. That doesn't mean we shouldn't go forward with the program.
Mr. Chairman, SMECO would like the Commission to approve the program as it already has. We believe that the pilot will render important, informative information by telling us how we can better reach these budget billing customers so that they can make informed decisions regarding Empower Maryland. How much they save is the statistical question, and whether or not, as Mr. McKeel mentioned, whether we can take that and make some really difficult statistical analyses based upon that. But we can see the needle move, and that's important. The main thing, I think, is are we reaching these customers, and to let them make the decision. And of course, I think that at that point we can see if the needle's moving at all. So I'm asking the Commission to approve the program as proposed back in April, and I'm here to answer any other questions you might have.
And that program would not include an auto pay component?
It would not include an auto pay component. As proposed, it was either auto pay or budget billing. SMECO chose budget billing because we have more customers involved in budget billing than we do auto pay, so it would reach more customers. And we believe that there are more low-income customers in budget billing than there are in auto pay, and we thought that was important.
Thank you.
Mr. Chairman, if I may, one more time. Mikhail Raker for the Office of People's Counsel. I think some of the discussion here today raises additional questions that need to be discussed. The Commission's order did note a distinction between budget billing customers and auto pay customers. However, there was no, to our knowledge, discussion in the work group as to why one particular set of customers, meaning budget billing or auto billing, was selected by the utilities. At the very least, that overview should be included in the pilot proposal for transparency and for details. And then in terms of which particular segment is targeted, there needs to be additional discussion as to the best means of targeting. MEA proposes some other possible low-cost or no-cost recommendations that may possibly include or help achieve statistical significance, but it's unclear if that will happen without some additional discussion. And then lastly, my point about historical analysis, we continue to think that that's an important factor, one that should be undertaken during and or before the pilot is launched. And as SMECO notes, they need about 4 to 6 weeks to conduct that analysis. And we and VEIC, our consultants in this matter, feel that would be extremely helpful to setting specific metrics and goals, which the Commission's order did ask for, and which we don't think have clearly been identified in the pilot proposal as filed. So we would continue to urge the Commission for some additional time and some additional instructions for the utilities to comply with these requests. So with that, I thank you.
I would generally never be opposed to granting additional time. It sounds like there are some extra issues that need to be ironed out. Although I'm still concerned with the fact that at some point along the way we went from choosing either or to both together, the auto pay and the budget billing. Seems like it'll adversely affect the statistical sample size, if that's what I'm gathering from the two utilities present today.
Well, Mr. Chairman, as Mr. McKeel mentioned, those two groups are very different groups. The budget billing group are customers who want an even amount that they're billed every month. And for whatever reason, it might be for their own budgeting purposes, it might be because they have difficulty in making their payments every month, and certainty is important. Auto pay customers typically are there for convenience. They want their bill paid without having to pick up the pen and write a check.
No, Mr. McDougall, I understand. Two different groups. They probably don't have a lot of overlap. I'm sure there are a few customers that are in both, but that might be a small number. Let me ask my fellow commissioners if they have questions.
I don't have any questions. I think that we're in danger here of letting the perfect be the enemy of the good. I think that we approved this program on budget billing, and it would be I would move forward with the program, and it is my belief that if this turns out to be a program within a year and a half, we can see that and then potentially ask the companies to extend it to an auto pay and see if there are differences there. But that's my view on this matter.
So my view on this is my thinking may be colored by a little frustration with the behavioral work group process and Empower, but I think there's a different dynamic now. One is we have a new manager assigned from the Maryland Energy Administration for this program, and I think that that's an important leavening factor that has been missing maybe a little bit, and that's not to be critical. It's just that sometimes these positions are hard to fill or keep filled at the state level. But I think it's important to have MEA's input, and I sense that there's some important input that can be given here if a small amount of additional time is granted. Two, I have no problem with bifurcating these two maybe distinct pilots. So if that's the result of an extra 30 to 45 days, I have no problem with that. But it does seem like there's an opportunity here to gain some consensus. I would ask the utilities, all the utilities, whether they're at the podium now or not, all the work group participants, if the commission decides, and it's what I would support, Mr. Chairman, is if there is additional time given, that all come back to the table in good faith, try to resolve some of these issues, and go forward, give us a product that we can do some good with instead of trying to figure out who's going to win this argument. I don't like that. I don't think that's what our work group process was set up for, and I don't particularly relish the idea of making a decision on one side of the ledger or the other not having had the full benefit of everybody's input. So I would be supportive of an additional 30 to 45 days and ask the parties to come back in good faith to figure out if we bifurcate these things, which may not be a bad idea, so we're not mixing apples and oranges, and that we get the data that we need, and we are cost effective. If MEA has some cost effectiveness ideas to input into the process. So I think that's the wisest way to go instead of deciding who's going to win and who's going to lose the argument here today.
Thank you.
Yeah, I tend to agree. Just so I'm clear, currently the program is bifurcated. Is that correct? As is being proposed by SMECO and PHI companies?
Yes, the program is bifurcated.
Yeah. Okay. So we are already at bifurcated. And do I understand that MEA, you're trying to help maybe provide input to make it a little more statistically significant? Is that correct? Is that what you hope to achieve in this
Right.
30, 45 days?
Yes. So the work group only had about 3 days after the draft was submitted to provide comments, to ask questions. There was a phone call. MEA does not believe that that was enough time to review, to make sure we had meaningful discussions on the pilot. We understand that it may be one or the other in terms of which experimental group is selected, but there were missing pieces that were not discussed properly.
Okay, good. And since we've had this conversation, I do agree now that the bifurcated approach is better. I didn't read our own footnote and noted that in our order we had combined the two. So I think that granting an extra 30, 45 days, hopefully with the input that MEA can provide, but I also very much agree with Commissioner Herman. Let's not make, hold out for the perfect. Let's just go with as good a program as we can possibly get, because I think we could get some very good, interesting results from this pilot.
I would agree with Commissioner Richard and Commissioner O'Donnell. I think that I was comfortable with moving forward with the project as filed in April, but the whole purpose of a pilot like this is to try and, at the end of it, to make sure we've got some data that's valuable to figure out what we'd like to do going forward. And the bullet points that MEA is looking for, they included them on page 2 of their comments, all seem like fairly straightforward pieces of data to request. So I'm not opposed to an additional 30 to 45 days for all of you to get back together and talk about it in the work group. Nothing wrong with work groups, so if that's what you'd like to do, then I think we'll be able to get something out of that will be valuable going forward.
Well, it appears that we have consensus. Any final comments?
I just want to say one more thing for the record, and I won't beat this dead horse. But when I look at page 10 of the initial work group report, we had consensus on these programs. And I'm okay if the commission wants to send it back. But my point is that the work group had consensus when it initially filed this report, recommending that we pursue the alternate pilot programs that we've proposed here. I understand if the commission wants us to go back to the work group, we will. We will participate in good faith, and we will do our level best to answer these questions. But I just feel like we had consensus. OPC was in the work group, although their representative changed. MEA was in the work group, although their representative changed.
Mr. McKeel, you had me right up to butt.
Do any parties request further guidance of the commission before going back into the work group? Okay. I recognize this may be frustrating for some, and I am still not terribly comfortable with these two pilots running on the same track. So I would be supportive of a bifurcated process, so please consider that as you enter your deliberations. I understand that we have our fall and power hearing is scheduled at the end of October, I believe the 25th and 26th of next month. That being said, I heard consensus of granting an additional 45 days for the work group to proceed on course. Any additional comments from the bench? I don't think we need a motion or a vote here. Thank you.
The next item on the agenda is item number 10, Baltimore Gas and Electric Company, filed on August 1, 2018. It's 2018 Semi-Annual Stride Report, case number 9331.
Michael Dean, again, on behalf of staff. Item 10 is the semi-annual Stride status report filed by the Baltimore Gas and Electric Company. Under Public Utilities, Section 4-210, gas companies may replace their older infrastructure and that may be subject to leaks by submitting a strategic infrastructure development and enhancement or STRIDE plan with an annual list of projects and estimated costs for commission approval, and the companies may then recover some of these costs through a surcharge. During a review of the annual list of projects in 2014, it was brought to the Commission's attention that some estimates of project costs and their estimated completion dates from the prior year had been very different from the actual costs, and some projects had not been
completed and closed out. The Commission in a letter order directed that a semi-annual report on project status and cost variances be filed. Staff has reviewed the semi-annual report of Baltimore Gas Electric and, as discussed in staff comments, recommends that the Commission note the filing. The Office of People's Counsel filed a letter, mail log number 221928, essentially stating that they had no concerns requiring Commission action at this time.
Thank you, Mr. Dean. Does Counsel for Baltimore Gas and Electric have anything to add?
Morning, Your Honor. Dan Herson again for Baltimore Gas and Electric Company. I want to thank staff for their helpful analysis and the charts that they put together. That was helpful to review. I'm joined today by two of my colleagues, Kevin Nelson, who's our Principal Project Manager for Stride, and Jason Manuel, who's our Manager of Revenue Policy. We don't have a formal presentation for you. I just wanted to make the remark that for us, the story this first half of the year has really been the weather. We started off really strong. Then we experienced significant delays because of the rain. And when we filed the mid-year report on August 1st, we noted that that was for information through June 30th of this year. Things didn't get any better in the month of July, as we all know. It's still our intention and our goal to catch up as much as we can, and I think we stated in the mid-year report we expect to get close to 97% of the asset replacement complete that we estimated at the beginning of the year. That's still our intention and our goal. We're shifting more resources towards Stride crews. We're working on weekends. We're trying to deal with getting the work done as quickly as we can. But the fact is, when it's raining really hard, you can't do the main replacement projects. I'm told that when you have those excavations open, there's flooding concerns, there's safety concerns. You can't literally fuse the plastic pipe segments together. I'm also told that when you're digging the service holes for service replacement, those are filling up with water very quickly. We can't just pump that water out. We have to pump it out in terms of shipping it off and to comply with environmental regulations. So it's not an excuse, it's just an explanation that we were really delayed this first half of the year. And it's our full intention to catch up, but that's really the experience we had. And we also had two separate events on our gas system. There was a pretty significant gas outage in Laurel due to a water main break in the city of Laurel. And then, of course, we had the flooding event down in Ellicott City again, which literally wiped out some of our gas mains. So we've had some challenges, but it's our intention to catch up as much as we can. And we're here to answer any questions you might have. Thank you.
Thank you, Mr. Herson. Any questions for counsel? Seeing none, is there a motion?
Mr. Chairman, I move the Commission note the filing.
Is there a second? All in favor?
Aye.
The motion is approved.
Item number 11 is Columbia Gas of Maryland, Inc., filed on August 1, 2018, its mid-year report on the status of the projects approved by the Commission on December 20, 2017, for recovery through its Infrastructure Replacement and Improvement Surcharge, IRIS, case number 9332.
Michael Dean on behalf of staff. Item 11 is the Stride status report filed by the Columbia Gas of Maryland Company, reporting on their project status and cost variance. The applicable law is the same. Staff has reviewed this semi-annual report, and as discussed in the staff comments, it recommends that the Commission note the filing. The Office of People's Counsel also filed a letter, mail log number 221929, stating that they had not identified any concerns requiring Commission action at this time.
Thank you. Counsel for Columbia Gas.
Mr. Chairman and Commissioners, Ken Christman on behalf of Columbia Gas of Maryland, and with me is Ken Fillion, our Principal Engineer. I don't have anything to add, but we would be happy to answer any questions the Commission may have.
Thank you. I just have one question, either for Mr. Dean or Mr. Christman. On the bottom of page 2 of the buck sheet, we state that Columbia Gas has abandoned approximately 2,600 feet of bare steel pipe and 520 feet of cast iron pipe out of an estimated 67,000 feet of cast iron and steel pipe. So, according to my numbers, you've only abandoned 3,000 feet of pipe of 67,000. Are you behind schedule, or is there a reason these numbers aren't making sense to me?
Well, I think the 67 is the total we have on the system.
Oh, okay. The way the sentence reads, I thought it was in 2018 you planned to abandon 67,000 feet.
If I could have just a moment.
Sure. They have 3 months to abandon a lot more.
Mr. Chairman, I'm not sure I can explain those numbers, but the fact is we're on target to complete all of our projects by the end of the year.
Okay, let me break it down this way. Are you planning in the year 2018 to abandon 67,707 feet of pipeline?
I think the answer to that's yes.
Okay.
It'll be basically 11 miles of pipe.
Okay. And to date, according to staff's buck sheet, the company has only abandoned approximately 3,000 of that 67,000, which would put you well behind schedule for 2018.
Yeah. That was as of June 30th. And as I said, I'm not sure I can explain that number, but as of the end of August, we've basically installed about 50,000 feet out of the 67,000 we plan to install this year.
Okay, so
we're well on target.
These numbers might not be accurate. Does the staff council or our engineer have any additional?
Good afternoon. My name is Additional Jayola from engineering. In their initial filing, what I looked at there is the projects that have been completed to date as of June 30th, 2018. So as of that date, they've only showed me that they've completed 28 feet of bare steel and 520 feet of cast iron pipe. And they have indicated in their filing that they plan to complete the whole project for 2018 by the end, by fourth quarter of 2018. So what I'm putting here is what they've presented to us.
As of June 30th?
Yes.
Yes, okay. Obviously, there's a discrepancy in the numbers, or the company still has 64,000 feet of pipe to abandon in the next 3 months.
Yes, I think the problem here is that as of June 30th, we had only completed 4 of our 19 projects. We have now completed 9 of our 19 projects. And again, as I said, we've completed about 50,000 feet of new construction out of the 67,000 we plan to complete. And we plan to complete all 19 projects before the end of the year.
Okay,
so we are on target.
All right, so it does seem like a lot of the projects were back-ended into the year. You still have 10 more projects out of the 19.
Well, some projects are longer than others, and I think this is just a function of the fact that there wasn't that much footage in the first 4 that had actually been completed when we did the June 30th report.
Would it be fair to assume that a lot of those significant projects were well underway when you reported on June 30th? A lot of the work was done. It's just the specific projects had not had the I's dotted and T's crossed to say they were completed.
Yes.
Okay, fair enough. That kind of explains the difference in the numbers in my mind.
Thank you for that that clarification. I have nothing further. Is there a motion?
Yes, Mr. Chairman. For item number 11, I move we note the filing.
Is there a second?
Second.
All in favor?
Aye.
Motion's approved. The filing is noted. Madam Secretary.
Item number 12 is Washington Gas Light Company filed on August 1, 2018, its STRIDE mid-year report covering the period ending June 30th, 2018, case number 9335.
Michael Dean again on behalf of staff. Item 12 is the STRIDE status report filed by the Washington Gas Light Company, reporting on their project status and cost variances. The applicable law is the same as the prior two items. Staff has reviewed the semi-annual report of the Washington Gas Light Company and recommends and noted its comments therein. And staff recommends that the Commission note the filing and direct the company to submit a status project list for its unfinished projects as of December 31, 2018. And the project's status list should include a listing of all unfinished projects and associated VCA, which is the company's unique funding project number, and the estimated completion date for that project.
Thank you, Mr. Dean. Counsel for Washington Gas.
Good morning, Mr. Chairman, Commissioners. John Dodge, appearing on behalf of Washington Gas Light. I'm joined this morning by my colleagues Wayne Acas, that's J-A-C-A-S, Aaron Stuber, and Frederick Jack Morrow. We don't have a formal presentation either. We are happy to answer any questions, and we are happy to agree to staff's recommendation regarding the December filing of our unfinished projects. As of right now, we do plan on finishing everything on our non-deferred list. There are 5 projects, I understand, that we are facing paving or other moratoriums from localities, but other than that, we are well past the halfway mark on our 2018 list. We are pipe complete on 89% of our program list, so we're in good shape coming to the close of the initial phase of our STRIDE plan.
Thank you, Mr. Dodge. Any questions for Washington Gas?
Quick question, Mr. Dodge, if I might. We've had this discussion before about cost variances and cost estimates, and in 15 and 16, it looks like the estimates were significantly lower than the costs, and then they start to swing the other way a little bit, it looks like to me, and we've discussed in the past how we may get closer to the actuals being what the estimates were. How's Washington Gas making out in that regard? Can you give us an update?
I'm delighted to report the patient is getting better, Your Honor. We have identified 3 internal means by which we can improve those estimates. They are, number 1, including a contingency factor, as is normal and logical in construction projects of this magnitude. Number 2, including an inflation factor. We did not build that into any of our original project lists. And number 3, we have a more discrete way to analyze by pipe length the project. So we are able to narrow down, if you will, some of the differences that were plaguing us in 2015 and 2016. I would note for the Commission's edification that today in our STRIDE 2 case, that's case number 9486, and in 9335, the case here today, we are filing the report on our dime of Continuum Capital. We asked them to look at that very question. They have identified, in addition to the 3 metrics or 3 measures that I mentioned to you, we've essentially had 20 or 25 huge outliers over the course of the initial 5 years. Harking back to your, I think it was your question, what's your root analysis of what's going on here? We had 20 or 25 projects that blew the cost estimates out of the water. If we remove the top 10, that is the most varied variances, our variance goes from 18% down to 10%. If we remove the top 20 or 25, there is no cost variance. So we are working hard to identify ahead of time, using those new metrics I just mentioned to you, any more potential outliers so that the gap decreases and hopefully disappears.
I think part of the original discussions were WGL was in its first cycle. It was a newer program. It was up and running. Of course, that explanation of cost variances has a limited shelf life, which is probably coming near to the end of its useful life.
Agreed, and you will see in our rebuttal testimony filed today in our STRIDE 2 case a better description of what I've shared with you today, and lessons learned from our consultant report, lessons learned from the discussions we've had with the Commission.
Fair enough. Thank you.
Mr. Dodge, I was having a little trouble hearing you earlier, but how is Washington Gas doing now that it's in September on the 15, 16, and 17 lists as well as the 18 project list? Because there's still some leftovers from several years back.
And I apologize, it's the first time in a long time I've been accused of having too soft a voice, Your Honor, and I take that as a big compliment. First, again, for the 2018 project list, we are well over halfway done. It's a bit difficult to get a snapshot, but we're at least 55% pipe complete for the 2018 list, and as BGE Council mentioned, some weather delays, but we are more than catching up, and we think we'll resolve the entire 2017/2018 project list by the end of the year, except for a few projects that were deferred for circumstances outside the company's control. For the others, I don't have with me specific data, but as of our filing this morning in our Stride 2 case, and as a courtesy in this case, we are 89% pipe complete. That means pipe out of the ground, new pipe in the ground for all years, including 2018, and 82% BCA complete. That means ministerially in our accounting and work management systems, we've closed out all of those projects. So we anticipate that from a program perspective, we will be at least 92-93% complete by the end of the year. That is pipe complete, and over 90% complete from a ministerial measure as well.
Thank you.
Seeing no other questions, is there a motion?
Yes, Mr. Chairman. I would move that we note the filing and direct the company to submit a status project list for its unfinished projects as of December 31st, 2018, which should include a listing of all unfinished projects with associated BCA and the estimated completion date.
Is there a second? All in favor?
Aye.
The motion carries and is passed. Thank you. At this time, why don't we take a brief 10-minute break? We'll be back here at 11:45, and we'll conclude with the final item on the agenda. We are back on the record. Madam Secretary.
Item 13, Delmarva Power and Light Company filed on July 26, 2018, errata, tariffs to correct a rate design error and request for expedited treatment, case number 9455.
Thank you. Mr. Spivak.
Thank you, Mr. Chairman. Good morning again, and good morning, Commissioners. Lloyd Spivak for the Commission staff. This is the further consideration of this filing by Delmarva, seeking to correct what they consider an error made at the conclusion of their last rate case, case number 9455. We said a lot the last time we were here. Since then, staff has prepared supplemental comments, and that says most of what we need to say at this point. Just a quick thing. First of all, at the beginning of this session, I handed out 2 additional data request responses that the company gave us. Those are simply things that should be added to Exhibit C of staff's comments. They were inadvertently omitted when the comments were made up. As for staff's comments, just a brief run-through. We do believe at this point that the Commission can legally correct an error in rates. The Commission can do as the company requests if it believes the existing record has sufficient evidence in it to support that action. Staff does, however, recommend that the Commission use a sounder procedure, or what we view as a sounder procedure, which would be to reopen the record and set the request for hearing. The additional information that we believe is necessary to go in the record is detailed in staff's comments, staff supplemental comments at page 4 and also at pages 8 and 9. We also believe that that additional information should take the form of supplemental direct testimony from the company.
Thank you, Mr. Spivak. I particularly found your appendices to staff's buck sheet very helpful, the legal citation as well as the responses regarding rate design issues. So we appreciate your team's hard work on that.
Thank you, Mr. Chairman. And one more point, we did reach out to OPC to see if there was any willingness to move on the issue, and there really does not seem to be at this point. But beyond that, I'll let Ms. Ryan explain where they are.
Ms. Ryan.
Thank you, Your Honor. Anna Ryan for the Office of People's Counsel. As an initial matter, I'd like to note the objections that we filed in written comments yesterday with the commissions. As a quick review, that simply is to reiterate our objection that we do not believe that the commission has the legal authority to make the requested tariff modification. We also believe that any modification would not be supported by substantial evidence in the record. And third, we object to the use of any information that is alleged to have contributed to the parties' understanding during settlement negotiations. I would like to add to that this morning a fourth objection in response to staff's proposed resolution in their most recent recommendation yesterday, and that is that OPC believes the Commission would commit an error of law by not only considering parole evidence, but by reopening the record 8 months after execution of the settlement agreement for the express purpose of creating post-agreement parole evidence that contradicts the terms of the settlement in order to modify a fully integrated contract. And I can explain that further in our response to staff's recommendation, but as an initial matter, I simply would like to explain that OPC will participate in any further proceedings ordered by the Commission in order to ensure that the interests of residential customers are represented. But OPC would like to have these four objections recognized as standing objections that will be in place for the duration of any proceedings on this issue, and that OPC's participation is subject to those objections.
Thank you, Ms. Ryan. Your objections are noted. Does OPC deem this proceeding today to be an invalid proceeding?
Yes.
Yet you are subjecting yourself as OPC counsel to participating in this proceeding?
Subject to our objections, we want to ensure that the dialogue does have representation for the residential customers.
Thank you. Mr. Michael.
Yes, thank you, Mr. Chairman. First of all, I would like to thank the staff for taking its further look and filing its extensive updated buck sheet. We, like staff, did reach out to the Office of People's Counsel, and they made clear their position. Obviously, we disagree with that. Just going to the merits, first of all, this is correcting a mistake. And we think it was a mistake made by all of the parties here, not just Delmarva Power, although Delmarva Power is largely responsible for the mistake. We believe that we have demonstrated through this proceeding that all of the information to demonstrate that the mistake was made is currently already in the record, and so there's not a need to reopen the record as requested by staff or to take, have another hearing on that topic. We believe that we have demonstrated in our initial filing of July 26, 2018, where that information is contained in the record, how you get to that number. We have not sought, and I don't believe that we have, gone behind any of the settlement discussions or settlement facts to get to that information. And we would ask, and we agree with the staff, that this commission certainly has the legal authority to correct errors in its orders, and we would ask that the commission take that step today. I have both Mr. Janoka and Mr. Zeminski are here to answer any further questions, as is Mr. McGowan.
Thank you, Mr. Michael. Do the commissioners have questions of the parties? Commissioner Herman.
Mr. Spivak, explain to me a little bit more in detail what the purpose of this hearing would be. Is it to put into the record the attachments that we already have, or what's the purpose of the hearing that staff proposes?
Going to what we said in the comments, it is to complete the record. What is in the record now with respect to this error is essentially the theoretical underpinning of an adjustment and a number that is close but not quite there as to what the actual adjustment is. What should be in the record is information on exactly how the error came about, how it needs to be corrected, something that takes us in detail through the calculation, that it thoroughly explains what the proper calculation is and how you get from that number and through a rate design.
Mm-hmm.
So,
Mr. Michael, I'll let you respond to that. Is that information in the record?
I believe it is, and I think the way we get there is on attachment B of our initial filing, Your Honor. And I think in their subsequent buck sheet and at the last hearing, the staff indicated that those numbers are indeed correct, and you can find them in the record. So I disagree, yes.
and my point is that that isn't what we have in front of us now is not actually evidence. It is essentially the proffers of counsel, and the proffers in staff's case as well of technical staff. It's not evidence in the record that such that the commission can use it to support a decision that needs to be based on an evidentiary record in a contested case, and that's where we're getting the disconnect.
Mm-hmm.
If I might, Your Honor, OPC did ask its consultant, Karl Pavlovic, to review the additional information provided by Delmarva in this case, and Mr. Pavlovic was unable to agree with the numbers included in Attachment B as provided by Delmarva. He reviewed the information and reached a different conclusion as to what figures should be included in that attachment.
And you have chosen not to include that information?
I have copies of that with me if the Commission would like to see that today. Again, I'm providing this merely for information, still subject to our objections.
No, not right now. Thank you. But thank you.
Mr. Michael, rate-making adjustment number 19. You had a witness who sponsored what I understand is the correct revenue requirement during settlement. Can you explain what was contained in rate-making adjustment RMA 19.
Right, so I'm going to let Mr. Zeminski explain it since he's in charge of that, so I don't misspeak, if that's okay, Your Honor.
So, adjustment 19, Chairman, relates to annualizing the impacts of the rate increase in case number 9424. So it's a rate increase that happened in the middle of the test period. So the test period includes some of that incremental revenue when those rates went into effect, but the full 12 months doesn't reflect that. So the purpose of the adjustment is to recognize the fact that the Commission has approved that level of revenues. Let's put that into our revenue requirement calculation so that theoretically don't ask for it twice. So that's what that adjustment does, is raises the revenue to the level that has already been approved by the Commission, so that for purposes of case 9455, the case for which we're dealing with, what incremental revenue increase are we going to eventually come to that we would add to that level of revenue? So we sort of set the baseline. Previously approved rate increases get factored into that, and then 9455, whatever increase would come out of that, would just be added on top of that.
And if I could add a little color about more information in the record, when you look at witness Efron for the Office of People's Counsel testimony with respect to the settlement agreement that he filed on behalf of that, when you look at page 1, there's a question on line 17 that goes over to page 2 that he describes where the differences in the calculation of the revenue requirement for the company and OPC stood. And he says that it's based primarily on Dr. Woolridge's rate of return recommendation, the difference in treatment of post-test year reliability plant, the use of average versus end of test year rate base, and treatment of merger synergies and cost to achieve, and the proposed rates of return. And so that's OPC's explanation of the difference in revenue requirements. In the record, not going behind, what the settlement discussions were or weren't, and noticeably absent from that discussion is any discussion about RMA 19.
Do the commissioners have additional questions? I believe in the sanctity of contracts. I believe in the sanctity of settlements, and I am loath to undo a settlement. But the way I've reviewed the evidence in this testimony, I do not believe that a vote to approve the revised tariff as submitted by Delmarva would modify the settlement in any way. I believe it's correcting for an error that prevents Delmarva from collecting the $13.4 million rate increase because of a mistake that I will place mostly on Delmarva's back, using an incorrect revenue requirement. The parties agreed to this revenue increase of $13.4 million in this settlement, but we have now discovered that Delmarva cannot recover the proper amount of revenue, and I believe all the parties before us today have conceded to that point. I also agree that the Public Utilities Act, Section 3-113B, permits the Commission to modify its orders for cause, and there's precedent stating as much in my review of staff's most recent buck sheet and Appendix A, which cites some legal authorities there. Therefore, I believe that Delmarva should be permitted to have rates on file that will allow it to collect its revenue requirement of $222.5 million. I recognize that Delmarva has already agreed to sacrifice the funding that it would have otherwise been able to collect had these rates initially gone into effect this past winter. For those reasons, I would grant Delmarva's request for revised tariff sheets. Thank you. Commissioner Richard.
I think you stated the case very well. I also agree that this was an error that was made. I think it's made on a basis of a known variable, the BSA. I listening to everyone, I understand that the data was behind the veil, I guess, at the during the settlement discussion, but it was available to everybody. So being a known variable, I think that a correction is justified. Otherwise, everybody agreed on the end result as far as the rate increase. And I also believe that if we were, the shoe were on the other foot at this point, that if this error had been made, against the ratepayers, we would be definitely looking to try to fix that on their behalf. So I think we need to be fair when a known error is made. And I also believe that the company has, conceded, by not going retroactive, that, it's their mistake, and I think that's a pretty big concession on their part to not want to collect the past rate. So I would also support the company's request to change its tariff.
Commissioner O'Donnell.
Thank you, Mr. Chairman. I am convinced that we have the authority to correct an error. I'm also convinced that the record is sufficient in this matter to grant the tariff changes requested that supports the settlement. So therefore, I'm ready to move forward today in supporting the company's request.
Commissioner Linton.
Thank you, Mr. Chairman. I agree with all the comments that have already been provided. I think that as it stands now, an argument could be made that we are currently we have not currently adopted a tariff that is in compliance with our order, and so that puts us out of compliance with the process and the orders that we currently have. So this is an error that throughout our Code of Maryland regulations, when the companies make errors, we're required to not only repair them going forward, but the company loses out on the funds that have already been lost to them and are unable to collect it, and we've seen that that's the approach that's been presented here. Errata tariffs aren't new. We've had to address this in previous cases, not with amounts of this size, but it's been done before, and so I think that's the appropriate approach here.
Commissioner Herman.
Thank you, Mr. Chairman. I concur with the statements of my colleagues and would move that we approve the tariff with an effective date of September 5th, 2018.
Second.
All in favor?
Aye.
Aye. Any opposed? The motion is approved. Delmarva's revised tariff sheets that were filed on July 26, 2018, move into effect today. Seeing no additional business before this commission, this meeting is adjourned.
Thank you, Commissioners.